Good evening. Happy Wednesday, part two. Boy, it kind of feels like it's Thursday to me, but what do I know? So, it appears that our good friend CJ Grisham, I'm suing a judge, he says. And this could be fun. So let's see what he has to say.
All right, guys. Hey, I'm going to cut that short. I want to get to this real quick because I don't want to make this a long video. I made a video earlier from my car and mentioned that we were going to try and file some motions about what happened yesterday in court, where a judge decided that he was going to follow the law and was going to keep my client from getting his gun back, which he has a legal right to do. The Texas law is very specific. You can see that video for more information on that. But I changed my mind. I'm not going to file a habeas corpus, or what I call a habeas pistola brief. I'm not going to file a writ of mandamus.
See, habeas corpus basically means something Latin for like bring the body or bring the person. And habeas corpus is like if you are incarcerated and you believe that you're wrongfully incarcerated, if you're in custody and you're wrongfully in custody, you can petition for a writ of habeas corpus and the person that you are basically suing, for lack of a better word, is the person who is in charge of the institution that is housing you. So like the warden, you'd sue the prison warden, right? In this, it's not really a suit, but in this petition, they'd be the respondent. So it has absolutely nothing to do with getting a gun. A writ of mandate might be an appropriate vehicle for getting the judge to do what you want him to do. A writ of mandate is where if you petition for a writ of mandate to the Court of Appeals, they will then tell the trial court, do this. It's a mandate. It's mandatory. Do this, right? They also have writs of prohibition and all sorts of different things. California figured out that attorneys just aren't smart enough to know what kind of writ to use. So the Court of Appeals will liberally construe what kind of writ that you're actually asking for. So if you call it the wrong thing, the Court of Appeals will figure it out. But there's also a strong possibility, I'm speaking as a California attorney. I'm not a Texas attorney, and theoretically CJ Grisham is, even though he has JD after his name there, and not Esquire, but whatever, I mean, he could stylize it as he wishes. But if it's a final order on a particular thing, if it's dispositive, then it should be appealable. At least in California, I would assume it would be appealable. We don't have that particular statute in California, at least not that I'm aware of. Never looked into it. But it could be appealable, and appeal is normally done after a final order. So typically after a judgment or something that settles the matter. So like if you have a discovery dispute and the judge rules against you on the discovery dispute, you'd petition for a writ of mandate or prohibition or whatever. But if the judge rules against you, like if on a motion to dismiss, if the judge rules against you, then that would dispositively settle the matter, so that would be an appeal. And they're handled slightly different, but I guess really it's a distinction without a difference as far as this is concerned. But a petition for writ of habeas corpus does not apply at all in this, or what do you call it, habeas gunus or something? Yeah.
Why? Because if I do that and we win, my client is out more money because he's got to pay to do all of this kind of stuff. Instead,
if we do it and win, my client's out more money. Well, if you're doing it pro bono, probably not. It'd just be the filing fee. But yeah.
we're going to sue the judge.
And see, there's where you're kind of losing me here. Suing the judge, I'm not really sure how you're going to do that, because there is this thing called judicial immunity, and it's not just in the federal scheme of things, but it's also in the state scheme of things. I tried to find the most recent cases possible. This is an 8-day-old case out of the district court in the Western District of Texas. And, it's citing federal cases. I mean, none of this is new or exciting stuff. I just picked the most recent case just in case the law had changed. An 8-day-old case is going to show you basically the latest law, because they're going to be citing well-established cases. And judicial immunity can only be overcome in two circumstances. First, a judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's judicial capacity. Well, in this particular case, according to CJ, The judge made a decision on a motion. CJ filed a motion. The judge heard the motion, and the judge has two options. He can either grant the motion or he can deny the motion, and he denied the motion. So it is in his judicial capacity. It's not in an administrative capacity, like if the judge was making like rules for how the courtroom was going to be run or something like that. This was a judicial action. Second, a judge is not immune from actions, though judicial in nature, taken in the complete absence of all jurisdiction. Allegations of bad faith or malice are not sufficient to overcome judicial immunity. Now, in the complete absence of all jurisdiction, let's say a judge ordered you to appear before him tomorrow, and there's no summons or complaint. There's nothing that granted him or that granted anybody standing to get you in court. You're not a criminal or anything like that, and you're not in his court for him to get jurisdiction over you. He doesn't have jurisdiction to tell you to be there. And if he finds you in contempt of court for not being there, well, then that's not, he doesn't have jurisdiction over you. So it could also be something where if he didn't have jurisdiction over the case or something like that. But in this particular case, CJ filed a motion to be heard by this judge. It's well established that the judge had jurisdiction to hear this matter. The judge had two options in this matter. He could grant the motion or he could deny the motion. He chose to deny the motion. And allegations of bad faith or malice are not sufficient to overcome judicial immunity. In addition, allegations that the judge made the wrong decision or, in quotes, failed to follow the law, end quote, is also not sufficient. It's from other cases. You could take me at my word or you could go Google it yourself. To determine whether an act was done in a judicial capacity, courts weigh the following factors. Number one, whether the precise act complained of is a normal judicial function. Yes. Granting or denying a motion to return a firearm is a normal judicial function. Whether the acts occurred in the courtroom or appropriate adjunct spaces, such as the judge's chambers. It occurred in the courtroom. We're batting 1,000 for judicial immunity so far. Number three, whether the controversy centered around a case pending before the court. Well, yeah, I mean, it was around a criminal case, and the criminal case was dismissed, but it was centered around that case. The whole reason the court had that gun, or the court had jurisdiction over granting or denying a motion on the gun, is because there was a case in front of the court. And number four, whether the acts arose directly out of a visit to the judge in his official capacity. According to what CJ said, he went to the judge to have his motion heard. So literally, he's batting 1,000 for judicial immunity. Now, in the Texas state courts, it's not that much different. A judge has absolute immunity from liability for official judicial acts performed within the scope of his or her jurisdiction. So it's the same thing. It has to be a judicial act. It can't be an administrative. It has to be a judicial act. And, this was granting or denying a motion. That's a judicial act. And it has to be within the scope of his or her jurisdiction. The case was in front of this judge. The motion was in front of this judge. The judge had jurisdiction over it. So it's the same thing, and he's going to lose either way. Now, what I find interesting is he never addresses...
the law's very clear on this. There is no...
He never addresses any of this. He never addresses judicial immunity.
Discretion that the judge is allowed to have in this issue. The fact that the law is very clear that once a person's charges have been dropped, the person is entitled. The word is entitled to have his firearm back, and the judge shall. Now, these are both quotes. Entitled is a quote. Shall is a quote. Return the firearm. However, this judge, what he thinks he's above the law, and that he recognizes that in most cases it will cost more to litigate the issue and get the gun back than it would be just to replace the gun.
Always be wary of people who read minds. Be wary of people who read minds, because CJ is a first-year attorney at best. At best, he's a first-year attorney. By his own admission, this is his first case. And that judge has, I think, a minimum of 10 years, to be a judge in Texas. He needs something like 10 years as a practicing attorney. So there is some difference in experience between CJ and this judge. And this judge probably hears hundreds of cases a year or more, depending on whether or not he's doing like arraignments and if it's like misdemeanor kinds of things, it could be a lot of cases. I mean, like not small claims, but like the traffic style cases. I mean, you hear probably like 3 or 4 of those in a day sometimes. But there's going to be a difference in the amount of skill and expertise, understanding between what CJ knows and what the judge knows. And the judge probably has a handy dandy little judge's bench book that if the judge had any question, he could probably refer to it and, go from there.
I don't think you realize that CJ Grisham is now an attorney, and that doesn't matter. We're gonna fight every corrupt politician in this.
The judge is an attorney. Being an attorney isn't that big of a deal to other attorneys. Now you're an attorney, and you could say, "Hey, John, you're a dumbass. You don't know what the hell you're talking about." Okay, I'm sitting here saying that you, another attorney, is a dumbass, and you don't know what you're talking about. So it loses its mystique. Judges tend, because they're just dealing with the same thing over and over and over again daily, they tend to know what they're doing pretty well. I do a general practice, so I do a little bit of everything, and I don't know everything about everything. I know a little bit about everything. And judges, there's anytime you're in probate court in Sacramento, it's the same judge, Judge Dillon. Right? It's the same judge every time. And, when they change out who's doing the probate court, you're like, oh, hey, who's this new judge, right? Or when Judge Dillon's on vacation, it's because he does it every day. So he knows more about what goes on in probate in Sacramento. He knows the local rules. He knows what needs to be seen, what needs to be done. These judges, they have a lot of experience, CJ, and, maybe you should understand that. I mean, you're talking about suing a judge, dude. And his whole thing about, if he wins the appeal, his client still is out the money. Well, if you win, well, you can't. You're not going to win if you sue the judge. And if you lose against the judge, your client may be liable for costs. And at least in California, if an attorney files a frivolous lawsuit, because you're an attorney now. I mean, I'm assuming you're an attorney now. You just said you're an attorney. I'll take you at your word. I mean, maybe the State Bar website is wrong. I don't know, and I don't really care. But you're an attorney now, and you're going to be held to the standard of an attorney. And if you're out there filing frivolous lawsuits because you're upset that a judge made a decision you didn't like, so you're going to sue the judge, dude, you're opening yourself up to the potential for sanctions or State Bar discipline.
This state, including judges. A lot of attorneys won't do that. A lot of attorneys won't sue judges, because they're worried about.
Yeah, attorneys don't sue judges because judges have judicial immunity, and the appropriate thing to do is to appeal.
Their license. They're worried about their relationships with judges and all that.
Yeah, they're worried about their licenses. Yeah, isn't that crazy?
Kind of stuff. I want to make something very clear. I became an attorney because I believe in the oath that we take as attorneys, and that oath is to our clients. That oath isn't to our judges. Now, obviously, we have to abide by court decorum and rules and things like that, and I plan to do that 100%. But that doesn't mean that I'm going to kiss the ass of judges. And I'm not going to kiss the ass of prosecutors. I'm not going to kiss the ass of other attorneys. I became an attorney for clients, not for the system, not for the bar, not for judges.
And this is actually what I was looking to have pop up. So, Mr. The Diff asks, does the judge lose his absolute immunity here? And that's something that CJ never addresses. And in fact, if you get to the end,
and make sure you include all the,
you'll see a few more people asking about judicial immunity. Here's Bota Bob. What about judicial immunity? CJ never answers that. CJ never answers that. So that's something that's interesting. So, Mr. Grisham, I wish you the best of luck on your suing a judge. I don't know why you're waiting till November. He's going to wait till November to file it. That doesn't make any sense to me. I've heard a theory that he might be waiting on getting back his bar exam results. If so, well, that's a problem, isn't it? And if not, I just don't know. Trust the plan, right? He's got to keep it secret. Trust the plan. All right, dude, your special case. Things get easier for you to win lawsuits in November. Whatever. Anyway, so thanks for watching. Good luck to you, Mr. Grisham. Chickenhawk, as you have named yourself. I didn't name him Chickenhawk, by the way. He named himself Chickenhawk. So if you think that I'm calling him Chickenhawk to be disrespectful, that's the name he chose for himself when he first came into my Discord server. And he said that he's had that nickname since he was in the Army. So there you go. Thanks for watching. Have a great day.